Hello, everybody.
All right, gentlemen, this is file 2500827SC, a small claims case, Taylor versus Duchette. We're here in small claims. What small claims means is that parties are trying to do this without any attorneys involved. Nobody is represented by a lawyer. And you're trying to do this right here in front of me, as opposed to asking for a jury trial or anything like that. I would be the one that makes a decision. So first things first, if you're both ready, willing, and able to proceed in front of me today, I'm going to swear you in. If you could raise your right hands. You swear or affirm that any testimony that you give here today would be the truth, the whole truth, and nothing but the truth?
Yes, sir.
All right. Are we expecting any other witnesses?
No, sir. No, sir.
All right. So I did get a lot of information ahead of time on this. There were several police reports and investigations. So it's my understanding, essentially, Mr. Taylor bought a car from Mr. Duchette for $6,500, correct?
Yes. I bought it for $7,000 total.
Oh, it was $7,000. You're suing for $6,500. All right.
Yes.
So you bought the car for $7,000. And then just sort of immediately had problems with it. Well, let me start with you, Mr. Duchette. Mr. Duchette, do you believe that you owe any money to Mr. Taylor?
No, sir, I do not.
Okay. I am going to caution you for whatever you testify to here today, just because you are now under oath and this is being recorded. Most of the time, when we have a situation like this and Mr. Taylor were to go to the police and say, hey, I think I got ripped off, the police would say, well, you know, we understand what you're saying, but when we take this to a prosecutor's office, they're going to say, well, these cases are hard to prove. Maybe you should just sue them in civil court, which is exactly what they told Mr. Taylor to do, and exactly what Mr. Taylor is doing.
Right.
I was a prosecutor for a very long time. This is not even a close call. You easily could have been prosecuted criminally for this. This is pretty much fraud. All right. So here's your problem, Mr. Duchette. First of all, this wasn't, you're not on the title to sell this car appropriately anyway. You know, you only have so long to switch the title from your name from the party you bought it from.
Right.
Right. You bought it from a different party for how much money?
$2,500.
Yeah. And then you turned around after a few weeks and sold it for $7,000.
Yes, sir.
Nice little profit for you, right?
Yes, Your Honor.
Quick profit in a quick amount of time. The problem is, it was pretty clear to you when you bought it for $2,500 what was wrong with it.
Correct.
It was not only in the advertisement, but the person you bought it from was very clear to the police officers during their investigation that you were informed and aware that, you know, this engine probably had to be taken out and replaced, that it needed at least a new piston rod, right?
Right.
But none of that information was communicated to Mr. Taylor.
Correct.
All right. And then Mr. Taylor sort of, you know, immediately has a problem. Mr. Taylor, I see the receipts here that what it would have cost to get the Subaru sort of up and running. Was that an estimate you got, or you did in fact put the $8,172 into the Subaru and it is up and running?
Those were two estimates that I ended up getting. However, I have currently spent about $4,500 on parts so far, and that's not including any labor yet to be done.
Is it up and running?
No, sir.
Okay. So essentially, here's what we have to do, gentlemen. A 2013 Subaru Impreza with 141,000 miles on it is worth about $7,000. But this car is not worth $7,000. This car needs a new engine. I find that the seller knew that or was aware of that. Mr. Taylor was not aware of that. So what we have to do is come up with the fair amount of money that one of two things can happen. Either Mr. Taylor can say, I don't even want this car, or Mr. Taylor is saying, no, I'm going to keep the car, but I want a certain dollar amount to sort of make this be fair. All right. So essentially, sort of right off the top, Mr. Duchette, you have $2,500 into this car, right? Because
No,
that's what you paid for it.
that's what I paid for it. Yes.
Yeah. And so you made about $4,500 profit selling it to Mr. Taylor.
Aside from, I did actually attempt to fix the rod bearing myself, which when he test drove the car, it was all fine, but apparently it didn't last, or something else went wrong, or something like that.
So essentially, the problem is this car is worth something because it's not worth nothing. I mean, other than it needs a new engine, it seems to me, you know, body's in good shape. A lot of other things are in good shape. Yes, Mr. Taylor.
I believe he is mistaken because he would not let me test drive the car, and he drove it and was gentle on it when we went for a test drive.
Yeah, and that was my understanding, that essentially the test drive, you were present, but it was Mr. Duchette driving.
Correct.
Yes, sir.
All right. But essentially what we're saying here is the car is not worthless. So you would not get your, you know, the full price that you paid back. Essentially what I need to do is find what is fair. What is fair right off the top is Mr. Duchette, I don't think should be making any profit off of this. Essentially what the car is worth, and then what we should give back. So it's difficult to figure. Essentially what you guys need is a third party, me, to go, boom, here's what I'm deciding, all right? And then you have to make your decision of whether or not you can live with what I've done, or whether you're going to appeal this and say, no, I don't agree with what just happened there. I want to take this to general civil back in front of the district court judges. So essentially, my ruling has two parts. One is we certainly don't want to have it that Mr. Duchette would profit from how this played out. I don't like the way this played out. I think this was deceptive at best. So we're talking about at least the $4,500. Now the reality is what is the car worth if you got to put the engine into it? And it looks like it would cost around what you paid for it to put the engine back in it. All right. So essentially, what I'm not going to do is say that the defendant owes the plaintiff the entire value of you know what was paid for the car, because then essentially you'd be getting the car for free, but for you have to put an engine in it. So I think what I'm going to do in this is I'm going to list this at $5,500 in damages. All right. Now, damages and costs are two different things. So I want you to understand the damages is what I'm ordering Mr. Duchette to pay Mr. Taylor based upon what I think is the fair value of money that should go back to Mr. Taylor. I do think this car is worth something. It's just not worth the $7,000 you paid for it. And so essentially what I'm saying is it might be worth around $2,000, but there is a little bit of, let's call it, damages just because of how it went down. So I'm ordering $5,500 in damages. What I need you gentlemen to understand is Mr. Taylor had to pay certain monies out of pocket to get us here today. He had to pay a filing fee to court, and he had to pay to have you served. That was $144.30. You are able to recover those costs on top of whatever damages are assessed. So I just wanted Mr. Duchette to understand where that sort of extra money comes to, because the judgment here is going to be for $5,644.30. Now, here's what you gentlemen need to decide. Well, either one of you can say, I don't agree with what just happened there. I want to take this to district court and go in front of the district court judges. Mr. Taylor, because you were asking for more than that, you were asking for $6,500, you did not get that, and you could say, I don't think that's enough, I want more. Mr. Duchette, you could say, I think that's too much money to be awarded to the plaintiff, I think it should be less than that. Either one of you can appeal my decision, but to appeal my decision, you must do two things. One is you must ask for that within 7 days of today's date. Your window of opportunity to take this further closes. After that, this decision is the decision. And two, you must ask for that in writing. You cannot just call up the court and say, yeah, I want to appeal. So I'm going to ask you both, do you understand your rights on appeal?
Yes, sir.
All right. If you accept this finding, both parties don't appeal it, then we expect the parties to be in touch with each other to sort of work out how and when the judgment gets satisfied, i.e. money changes hands. But as far as what we do here in front of me right now, that we are all set for what we need to do today. I'm going to go ahead and release parties. Thank you.
I do have one question, Your Honor.
Well, he's not here anymore. Go ahead and ask your question, but if it's ex parte, meaning you're here, he wasn't here, I can't really answer it, but it might be a question I can answer. Go ahead.
General question. I just need to know how I can transfer that money over to him legally. Like, is there a certain process I have to do, or is that just...
I will just say this, the court doesn't do the collection, so we do expect that the parties would be in touch with each other. So when you get a copy of this order, let's see here. I just want to see if on the, I mean, it should have everybody's at least address on the affidavit and claim. And so you'll get a judgment. And I want to see if it has phone numbers. It does. It has phone numbers on it. So when you get a copy of the judgment, you should have the contact information you would need. All right?
Okay.
Make
so
sense?
I would just have to reach out to him, basically?
Yes.
Okay. Sounds good. Thank you.
All right, gentlemen, this is a citation that was issued on April 2nd of this year on Blue Star Highway there, City of Saugatuck. It's a speeding citation on an actual 55 and a 35. However, it was only written as 6 to 10 over. Mr. Crabtree, you are here on this citation to do one of three things. First is you could admit responsibility to the citation. Or two, admit responsibility, but you'd like to provide some sort of explanation as to how or why this happened. Or three, you wish to contest this citation. In other words, fight the ticket at what we call informal hearing. What were you looking to do?
I want to contest.
All right. Then even though I cannot see you, I'd ask that you raise your right hand, same way the deputy is going to raise his right hand. You swear or affirm any testimony you give here today would be the truth, the whole truth, and nothing but the truth.
Yes, sir.
I do. Yes, sir.
All right, Mr. Crabtree, it makes a lot more sense for me to start with deputy. He has the burden to establish to me why you were issued a citation in the first place. But then after that, you'll have an opportunity to either ask questions or testify on your own behalf. And with that, deputy, you want to pick up the narrative somewhere it makes sense, explain the issuing of this citation.
Yes, Your Honor. So when I issued the citation, I was, or I should say, before I issued the citation, I was running stationary speed enforcement near the intersection of Blue Star and Lake. I was facing southbound on the eastern side of the roadway, Blue Star Highway, just north of Lake Street. As I was doing so, I noticed the suspect's vehicle traveling northbound across the bridge that connects the cities of Saugatuck and Douglas. I noticed that this vehicle appeared to be traveling much faster than the posted speed limit of 35 miles per hour. I then activated my front-facing stationary radar device, which was reading solely the traffic that was coming at me and no other traffic. The defendant's vehicle was the only vehicle in this zone at this time. As I activated it, it showed me that the defendant's vehicle was traveling 55 miles per hour in the 35. Upon seeing this, I turned around my patrol vehicle and followed the defendant's vehicle until I was able to catch up with him on Old Allegan Road, just east of Blue Star Highway, so about a mile away. I explained to the defendant why I was stopping him. He did not agree with me. Eventually, him and I came to a bit of an agreement. We calmed down a little bit, and I only ended up writing him for 45 and a 35 as opposed to 55 and a 35. I should also note that my radar is calibrated at the beginning and end of every one of my shifts.
All right. Mr. Crabtree, what is it you'd like to tell me?
My wife is also here, Amber Crabtree. It's funny because I asked him if he had video because I had my cruise control on, and he also said that he couldn't see the proof of insurance. Well, I got enough of those tickets to know that that's automatically on your guy's computer. I just got tagged. I didn't even need to show my proof.
Sir,
So,
you don't have a
I don't know
ticket.
what the deal is.
You don't
I
have a
have my
ticket for
cruise
no
control
proof of
on.
insurance, sir. I just need to know what speed you think you were traveling. I have testimony you were traveling 55 and a 35.
No, I wasn't. Me and my wife were just talking about my speed, and I was telling her I had it on cruise control. That's why when he walked up, I asked him if he had it on video. And then he said that he needed my insurance. I said, you got it on your computer. He said, no, I don't. So he lied to me.
Anything further you'd like to add, sir?
And my wife was right here as witness.
Yep, I was there, and he was not traveling that fast, sir.
All right. Anything further you'd like to say?
Nope. I've gotten
All right.
tickets
Well,
for
sir-
speeding. If I was, I would have just pled guilty and paid it. But this time I wasn't.
All right. So, sir, the evidence I have before me is that the deputy has you going 55 in a posted 35, as evidenced by his testimony and his radar that he says was in proper working order that day. You just said, no, I wasn't. And your wife said, no, you weren't. I have no evidence on your side of you going how fast you think you were going. So I would have to decide that I find that you were, that there is enough evidence here to find you responsible on this citation.
That's unfair.
What's that?
That's not fair. That's very unfair. No,
Sir,
I was not
I
speeding.
gave you
I
an
had my cruise
opportunity. You
control
didn't
on.
even tell me what speed you were going. You just said you had your cruise control on. That doesn't help
About
me at
40
all.
miles an hour. I was going
That's the
40
first
miles
time
an
you
hour.
just said that, sir, after proofs are
I'm
closed.
sorry. I thought I said that.
No,
I
sir.
apologize.
And your wife
sir.
didn't
I apologize.
either.
I thought
And
I said I was going for it.
I asked you and your wife multiple times if there was anything further you'd like to say as far as your testimony. You never provided an alternative to the deputy's testimony that you're going 55. So here's what I will tell you. Because you had an informal hearing, you do have a right to go to formal hearing. Formal hearing is in front of the district court judges with the prosecutor's office. I shouldn't give you legal advice, but you would need to testify to a speed less than what you're accused of going to have any chance of winning. But in order for you to go to formal hearing, you'd have to do two things. One is you'd have to ask to do that within 7 days of today's date. Your window of opportunity to continue to contest this ticket closes after 7 days. And two, you'd have to come in and post a cash bond in the same amount as the fine to guarantee your appearance at formal hearing. Do you understand your rights on appeal?
I do. Now, why do I got to go pay if I'm innocent till proven guilty? I have the right to appeal.
Because, sir, at formal hearing, well, first of all, this is not a criminal matter, sir. It's not, we don't talk like innocent or guilty. It's a civil infraction. But in order, the formal hearing includes subpoenaing witnesses. The prosecutor has to be present. There's a certain cost to the court in order to hold a formal hearing. And for you to set up formal hearing and then just not show up costs the court, like I said, an amount of money. So they make you post a bond to guarantee your appearance at formal hearing. The bond is the same amount as the fine. If you win at formal hearing, you get that money right back. It's only if you would continue to be found responsible, they would use that for fines and costs.
I would have taken responsibility if I had been speeding. I've had enough tickets, and I'm not, I'm just saying that. I know I had my cruise control on. I was just talking to my wife about my speed.
Even the cruise control that you told me is still speeding, right?
It's 40 miles an hour.
40 and a 35 is 1 to 5 over.
And you're allowed to go 5 over.
Well, not if you get a ticket. My job is to decide if you were going a certain amount over the limit. If you were written for 5 over and you're going 5 over, you would be found responsible. I don't want you to think there's a certain amount of speeding you're allowed to do.
I've been told that it is legal to go 5 over. I mean, I can look that up. I
don't know who told you that, sir, but I can guarantee you that's not correct. 1 mile over is still speeding if the officer were to decide to write you a ticket for that. But we're all set here. I'm going to release parties. Thank you.
Be safe, be well, sleep sweet, and much love.